In this lecture, we will see and understand the constructive trusts. Constructive trust is arising under certain circumstances. As we have seen, chapter 2 of the Trust Ordinance deals with express trusts. Likewise, chapter 9 of the Trust Ordinance deals with constructive trust. What is constructive trust? An obligation in the nature of a trust created under following circumstances defined as constructive trusts. Section 82 provides that an obligation in the nature of a trust, hereinafter referred to as constructive trust, is created in the following circumstances. The circumstances are given under chapter 9 of the Trust Ordinance, which creates trusts. Circumstances are given under chapter 9, under which trusts are arising. Where it does not appear that the transferor intended to dispose the beneficial interest. The concept here under constructive trust, a property is transferred to another person, but the transferor did not dispose the beneficial interest of the property to the transferee. Then from the circumstances we can identify, or we must be able to identify, whether the transferor intended to dispose the beneficial interest of the property to the transferee. A constructive trust is one which is not created by express or implied act of a settlor or author of the trust, but which is deemed by operation of law or arises by construction of law. The constructive trust is not created. When we study these express trust under chapter 2 of the Trusts Ordinance, we have seen that trust is created for some purposes. Here under chapter 2, trust is deemed, or trust is arising by operation of law or by construction of law. Because there is no express intention to create a trust. Transaction is there which amounts to the trust. That is constructive trust. There is no express intention to create the trust. where a person who is a legal owner of the property but is in fiduciary position as regard to another person in respect of that property, he is compelled by the doctrine of equity to hold the property for the benefit of that other person, that is constructive trust. It may be correct under English law because in Sri Lanka there is a chapter dedicated for the purpose of creation of constructive trust. Therefore, the circumstances are given under that chapter. We can create a new circumstance to create a trust or constructive trust. But under English law, case by case, we can decide whether there is a constructive trust because we are applying the doctrine of equity to hold the property for the benefit of another person. However, here we can see a person who is a legal owner of the property, but at the same time, he is in fiduciary position as regards another person in respect of that property. The both circumstances, both situations we must consider. First, he is a legal owner. There is outright transfer or absolute transfer. The property vested on such person. He is the legal owner of the property, but at the same time, he is in fiduciary position in relation to another person, in relation to the same. In that case, he is a trustee, not that owner of the property. That we will see later also. Section 5. Since Section 5 is to be read with Section 6, trust created under Chapter 9, Chapter 2 would be those where there is an intention to create a trust. And such intention may be manifested in the form prescribed by Section 5.1 or Section 5.2 on the proof of fraud by parole. That we have already studied in our express trust. The express trust may be created in terms of Section 5, especially if it is in relation to the immovable property in terms of Section 5.1, if it is in relation to movable properties, then Section 5.2, the trust may be created. But it should be subject to Section 6 because it is in relation to the reasonable certainty. Section 6 provides the reasonable certainty of certain matters specified in that Section 6. Trust arising under Chapter 9. Now when you read, there are two phrases here. The trust created under Chapter 2. Trust created under Chapter 2. When you come to the second paragraph, a trust arising under Chapter 9. Because trust created, the word created, you can use it when a person with the intention to create the trust creates a trust. Once again, the trust created under Chapter 2 in the sense, the trust created, the word created may be used where a person with the intention to create the trust creates a trust. But under chapter 9, different situation. Trust is arising, not creating. Trust is arising. There trust is created, here trust arising under chapter 2. Must fall one of the categories specified in sections 82 to 98. Section 83 would include the cases where there is a specific intention not formally expressed to create a trust in favor of settlor. Where there is no specific intention not formally expressed, but under chapter 2, the author of the trust with the intention to create the trust creates. But here there is no author of the trust. There is a transferor, transferee, not author of the trust at all. The transferor transfers his property to transferee, but in certain circumstances it amounts to the constructive trust. As we have seen up to now, chapter 2, specifically sections 5 and 6, chapter 9, sections 82 to 96, section 107 of the Trusts Ordinance govern the origins of the trust. On the basis of creation of trust, we can say trust may be created under chapter 2, trust is arising under chapter 9, or trust is declared under 107. These are the three main origins of trusts. Section 5.1 and 5.2 read with section 6 fall within the category of express trusts that we have already studied. Section 5.3 read with section 5.1, 5.2 and 6 falls within the category of informal trust that we have seen. Now we are saying chapter 9 is headed under constructive trust. All three are origins of trusts. Under section 107, a trust may be arising even in the absence of written declaration of trust as required by section 5, or in the absence of valid legal conveyance to the trustee as required by section 6, and such trust may be imposed on a person who never agreed to be trustee. When you see the 107 of the Trusts Ordinance, it provides that in dealing with any property alleged to be subject to a charitable trust, that it is limited to only charitable trust, not to the private trust. In dealing with any property alleged to be subject to charitable trust, the court shall not be debarred from exercising any of its powers by the absence of evidence of formal constitution of trust. By the absence of evidence of the formal constitution of trust, that means there's no deed of trust at all, doesn't matter. If it shall be of the opinion, the court of the opinion, all the circumstances of the case that a trust in fact exists or ought to be deemed to be exist, then there's a trust. That's why this is known as de facto trust. Therefore, here we say that under section 107, a trust may be arising even in the absence of written declaration of trust. There is no deed of trust, as in terms of section 5. In the absence of valid conveyance to the trustee as required by section 6, such trust may be imposed on a person who never agreed to be a trustee. All these things are there, but still court has the power to declare that there is a trust in relation to the charitable trust, not anything else. As we have seen the origins of the trust, chapter 2, express trust. Under chapter 2, section 5.3, that is informal trust. 107, de facto trust. Chapter 9, sections 82 to 98 deal with constructive trust. Whatever it is, in Muttama vs. Tyagaraja case, Sansoni CJ said, the dividing line between the express and constructive trust is very thin, and some cases fall within both categories. Even though we have divided the origins of trust, some cases it's very difficult to say whether it is a constructive trust or whether it is express trust. Now we will come to section 83 of the Trusts Ordinance. Now we must read this section very carefully. Where the owner of the property transfers or bequeaths it, and it cannot be inferred consistently with the attendant circumstances. That's the main words here. Attendant circumstances, that he intended to dispose the beneficial interest therein. Then what we should do is transferee or legatee must hold the property for the benefit of owner of the property. If the owner dies, then he must hold the property for the benefit of owner's legal representative. Now here, simply we will make it very simple. Owner of the property transfers, but from the attendant circumstances, we can't infer that the owner intended to dispose the beneficial interest to the transferee. Now there are two things we must consider. There are two main features here. First thing is ownership of the property. Second thing is beneficial interest on the property. Ownership of the property, beneficial interest of the property. For example, A transfer the property to B. Then what happened? B becomes owner of the property. B is the legal owner of the property. But we must see whether A transfers the beneficial interest of the property to the transferee. Generally, as we have seen in the example, A transfers the property to B. That's on the face of it, prima facie, that's outright transfer or absolute transfer. But A did not intend to dispose the beneficial interest of the property to the transferee. Then something outstanding. Even though B is the legal owner of the property, something outstanding, that means the something with the owner of the property, that is the beneficial interest. How to identify these things? How can we identify these things? We must see the attendant circumstances. Attendant circumstances are very important to identify the intention of the transferor. For example, A transfer the property to B only for the purpose of enabling B to get a bank loan. Once everything is settled, then the B must retransfer the property to A. That may be the understanding. A transfer the property to B to enable him to get a loan from the bank. Once settle the loan, B must transfer the property to A. That's the agreement. That's understanding. In that case, A transfer the ownership to B, not the beneficial interest. The beneficial interest, A never intended to dispose the beneficial interest to B. That's the idea, you keep it in your mind. But when you see the attendant circumstances in different cases, you may understand clearly. Now Sandradasa versus Hemalada, Supreme Court Appeal 168/14, decided in 2017 August 8th. The transferor is duty bound to adduce the evidence to show that he did not dispose the beneficial interest of the property. Because A transferred the property to B, now A is the plaintiff. Because A files a case in the district court and asks that to declare that B holds the property, definitely B is the legal owner. Then B holds the property for the benefit of A. In that case, if you want to declare a trust there, then the transferor is duty bound to adduce the evidence to show that he did not intend to dispose the beneficial interest of the property. He is obliged to adduce evidence to show the attendant circumstances that there was no intention to transfer the beneficial interest. He transferred the property, but he had no intention to transfer the beneficial interest to the transferee. Section 83 declares that where a property is transferred or bequeathed and it cannot be inferred that the beneficial interest was disposed of, the transferee or legatee is the trustee of the property. Property transferred, but from the attendant circumstances, it is established that beneficial interest was not disposed of. In that case, transferee becomes trustee of the property. Section 83 places emphasis on the intention of the transferor and does not refer to the payment of consideration. But whether the payment has passed would be an element in arriving at the transferor's intention. Always under section 83, we must be able to identify the intention of the transferor, whether he had the intention to dispose the beneficial interest. And also, if we want to create a trust there, we must establish from the attendant circumstances the transferor did not intend to transfer the beneficial interest to the transferee. Payment that the consideration passed would be an element to identify the intention of the transferor. But it can't be the one and only evidence to prove the constructive trust or intention of the transferor. Now we will see the illustrations given to section 83 of the Trusts Ordinance. A conveys the land to be without consideration, and declares no trust of any part. It cannot consistently with the circumstances under which the transfer is made reasonably be inferred that A intended to transfer the beneficial interest in the land, then B holds the land for the benefit of A. A transfer the property to B without consideration, but in the deed of transfer, nowhere the term of expression trust is used. That's why we are in the illustration. It indicates that declares no trust of any part of the document. Then there are three matters. One thing is property transferred, no payment given, at the same time no trust declared in any part of the document. It cannot consistently with the circumstances under which the transfer is made reasonably be inferred that he intended to transfer the beneficial interest. Then from the circumstances we can't say that he intended to transfer the beneficial interest to transferee, then the transferee B holds a property for the benefit of trust. There's a constructive trust arising out of this illustration. Now we will see illustration B to the section 83 of the Trusts Ordinance. A transfers certain stock belonging to him into joint names of himself and B. It cannot consistently from the circumstances under which the transfer is made as given in illustration A, reasonably be inferred that he intended to transfer the beneficial interest in the stock during his life, then A and B hold the stock for the benefit of A during his lifetime. Now here we don't use the word trust at all, even the illustration A and illustration B. Never ever we use the word trust. but still trust is arising. Then we will see illustration C of or to the section 83 of the Trusts Ordinance. A makes a gift of certain property to his wife B. She takes the beneficial interest in the land free from any trust in favor of A. It may reasonably be inferred from the circumstances that gift was for the B's benefit. Therefore, the beneficial interest transferred to B, therefore, there is no constructive trust arising out of these circumstances. Now we will see, actually we are going to see the circumstances, that is the attendant circumstance in each and every cases. First place, as we have seen, owner of the property transfers. That's the way we have seen in section 83. Where the owner of the property transfers, then the owner should be there. That's why here we, in the Patrick Pereira versus Leonard Fernando case, Supreme Court Appeal 101/16 decided on 2017 December 5th. It is only the owner of the property who held the property before transferring the same to another who can claim the benefit of section 83. Then always, owner of the property who has transferred the property to another person can claim the benefit of section 83, not anybody else. Suppose A transfer the property to B, then B transfer the property to C, then A cannot get the benefit of section 83 because A transfer to B, B transfer to C, then B can get the benefit of section 83, not A. Where a person has a notarial conveyance in his favor, the courts have placed heavy burden on the transferor to prove the facts, bringing himself within the provisions of section 83 of the Trusts Ordinance. Because there is a notarial conveyance, there is a transfer, outright transfer, absolute transfer, prima facie, there is a bold blank transfer, property transferred to B. From the example that we have discussed earlier, A transfers his property to B, B is the legal owner at all. But court placed a heavy burden on transferor to prove bringing himself within the section 83. Proof by a person relying on section 83 that he made voluntary conveyance to a stranger is not enough. He must prove always he did not intend to transfer the beneficial interest. Always the requirement is, in terms of section 83 of the Trust Ordinance, he must prove that he did not intend to transfer the beneficial interest. Now we will move to other slide here. Section 83 refers to the owner or legal representative, would not apply where A transferred the property to B, not stating the conveyance that he intended to benefit C. As we have seen in section 83, in terms of section 83, A transferred the property to B but he did not dispose the beneficial interest to B, then B must hold the property to A, not to any other person. In Gunavatana versus Sinapula case, the land was conveyed first defendant on the express verbal understanding that she was to convey to her son S when his debts were settled. The learned judge came to the conclusion that no consideration was paid. He held that the defendant held the land in trust for S and decreed her conveyance. On appeal, Ennis ACJ held that there is no reasons to interfere with the decision given by district court. Now the idea here is A transfer the property to B, the B actual idea intention, the A intended to transfer the property to C, but C has so many debts, that's why A transferred the property to B on the verbal understanding that that B will transfer property to C once the loan is settled. But the court said that B hold the property for the benefit of A. But in terms of section 83, it can't be. Because when you apply the literal rule of interpretation here, A the owner of the property transfers the property to B. Then B must hold the property or for the benefit of A, or if A dies, then B must hold the property for the benefit of legal representative of A, not anybody else. But still, the court widened the scope. Now we will see Gunavatana versus Gunavandra. Now in this case, C argued that B held the property on trust for him. C stated that his father asked him by letter to quit government service and return to home, and that the father promised to him he will convey the land on which the mill was situated to him. That C acted on his promise and gave up his job. That the father intended to carry out his promises but died before doing so. That the father's will, all his property was bequeathed to his wife, that's C's mother. The Bertram CJ said that C had an equitable claim and also referred to C's claim to an equitable rights based upon a trust. But when you apply in terms of strictly, if you apply the provisions of 83, you can't come to this conclusion. You can't come to the conclusion because here father promised and to the son, he gave up the job and he came back to home. But father asked him to resign the job. He resigned and he came back to home. He promised to give the mill situated in the land, but before that father dies. That's why in terms of the will, all the property vested to the wife, that's C's mother. But still, court apply the equitable principles, equitable rights, and decided that wife, the mother holds this mill, the land situated, the mill situated on the land, for the benefit of C, therefore the trust is arising. But the court did not mention section 83 or any other section in the trust ordinance. That's why L.J. Murray suggested that this section could be amended by the addition of words legal representative of the words other person intended to be benefited. Then the case will be under this section 83, because A transfer the property to B, then B must hold the property for the benefit of A. That's the situation that we have seen under 83. Once again, A transfer the property to B, but he did not dispose the beneficial interest to B, then B must hold the property for the benefit of A. If A died, then B must hold the property for the benefit of legal representative of A, not anybody else. That's why if the A intended to transfer the property to C, then what a situation? We can't come to give effect to that trust. That's why L.J. Murray suggested an amendment to section 83 by adding words legal representative or other person intended to be benefited. Now we will see attendant circumstances. Attendant circumstances is a very important words in section 83. In section 83 have been described as those which precede or followed the transfer. Circumstances, attendant circumstances should be precede or follow the transfer, but are not too far removed in the point of time to be regarded as attendant. Attendant in the sense it should be joining with the close join with the transaction. Precede or follow the transaction. Whether the circumstance is attendant or not would depend on the facts of each case. Premavadi versus Jnanavadi, 1994, 2 SLR, page number 171. An undertaking to reconvey the property sold was by way of non-notarial document, which is of no force or avail in law under section 2 of the Prevention of Frauds Ordinance. Don't use the word Frauds Ordinance, you must say in full Prevention of Frauds Ordinance. Because in a property transfer, there is an understanding, there is a document, non-notarial document. That means not notarially executed. What's the meaning of notarial executed? It should be in terms of section 2 of the Prevention of Frauds Ordinance. But the non-notarial document which has no force in law, because it is in violation of section 2 of the Prevention of Frauds Ordinance. However, the attendant circumstances must be looked into, as plaintiff had been willing to transfer the property on the receipt of 6,000 rupees within 6 months, but couldn't do so despite of tender of 6,000 rupees within 6 months, as he was in the hospital. The possession of the land had remained with the first respondent, and the land itself was worth of 15,000. There's a big disparities in the value of the land, and also there's understanding, there's a non-notarial document is there. Right, we'll see the next, we'll go to next slide and see. the court stated, the facts and the circumstances of the case point to a constructive trust within the meaning of Section 83 of the Trust Ordinance. The attendant circumstances show that first defendant did not intend to dispose the beneficial interest of the property. In other words, the attendant circumstances show that the first defendant did not intend to dispose the beneficial interest in the land. Then from this case, what we are learning, we must identify the intention of the transferor. In this case, when you see that there's a non-notarial document to reconvey the property or retransfer the property. In addition to that, there's a disparity in the price or the value of the property. Actually, property transferred for the 6,000 rupees, but real value was 15,000 rupees, more than double. And from these two circumstances, the first one is there's a non-notarial document to reconvey the property. Second, attendant circumstance is that the price disparity. When you put together, you can say, you can presume or you can infer that the transferor did not dispose of beneficial interest. Agreement to reconvey. That's another interesting matter here. A may transfer the property to B by notarial conveyance for the stated price, subject to the agreement to reconvey on a tender of purchase price with the interest within the stated price period. Now, agreement to reconvey. A transfer the property to B by way of notarial documents. That means that's absolute transfer for a stated price. Subject to a reconvey agreement. What is a reconvey agreement? On the tender of such purchase money plus interest within the stated period, then B must transfer the property to A. That's known as agreement to reconvey. This problem which confront the court depend on whether the agreement reconvey is notarially executed and signed by transferee, or mentioned in the notarial document conveyancing the property but not signed by transferee. Third one, alleged by transferor by parole evidence. By parole evidence. Now we will see the next slide here. In first one, what is the first one? Notarially executed and signed by transferee. The agreement to reconvey is enforceable only if the purchase price tendered within the stated period. After that, A cannot prove by parole evidence that the transaction was in reality a mortgage, and thus rely on the maxims once mortgage, always a mortgage, and enforce the agreement after a specified period has been lapsed. The second one has been held to fall within section 96, that we'll see now. Third situation. What's the third situation? alleged by the transferor by parole evidence. Alleged by the transferor by parole evidence. In item 3, where there is notarial conveyance absolute on the face of it, A cannot prove by parole evidence that the transfer was subject to an agreement to reconvey on payment of the purchase price with the interest. Now in the third one, as we have seen, anyway there's absolute transfer. Now the transferor alleges that there's a parole evidence, oral evidence saying that B agreed to transfer property to A on the payment of purchase price plus interest. Where there is a notarial conveyance absolute on the face of it, A cannot prove by parole evidence that transfer was subject to agreement to reconvey on the payment of purchase price with the interest. That we will see later very clearly, this part. Since the parole evidence is admissible to prove the trust, a party who has transferred the property subject to agreement to reconvey, either after a specified period lapsed or because of the agreement is a parole one seeks to argue that transaction is a trust. Since the parole evidence is admissible to prove the trust, there is no restriction or the limitation to submit a parole evidence to prove the trust. But still, a party who transfers the property subject to this agreement or reconvey agreement, after the such period is lapsed, or because of the agreement is a parole one, seeks to argue that transaction is trust. In this situation, courts have posed the issue: is there any plain agreement to reconvey, or are there other facts which show that agreement to reconvey amounts to the trust? Agreement to reconvey, there's an agreement that amounts to the trust. If we prove that, then constructive trust is arising. It is submitted that some of the cases which has decided that parole agreement to reconvey amounts to the trust. Therefore, parole evidence is admissible, and also you can submit such evidence before the court for the purpose of prove the constructive trust, not to contradict the document what is in or which is in writing. In Catholics versus Pereira, the land transferred as security for debts of 5,000 rupees, subject to reconveyance on payment of that amount. This was regarded as creating trust. Fernando versus Fernando, notarial document of the land value at 2,000 rupees by a man seriously ill for a stated purchase price 600 rupees. See the difference between the price. The transferor remaining in the possession, subject to parole agreement to reconvey if the transferor recovered from the ill, was held not to create the trust. Because there are issues here. Now see the difference or the disparities of the price. And second thing, you can see the circumstances, the man, he was seriously ill at the time of execution of this deal. Second thing. And third one, the transferor remained in possession of the land even though the property transferred. And fourth one, the parole agreement to reconvey. But still the court held that not to create the trust. The transfer being absolutely entitled, in all the probability, the transfer was effected in tacit conditions set out in the plaint. But that condition that the plaintiff is not in a position to prove, that's the thing. All these things must be proved as he was purely an oral agreement, it is existed at all. Plaintiff cannot rely on the resulting trust because lack of evidence to prove those facts. Price disparity, and he was ill at the time, seriously ill at the time, and the parole evidence or agreement to reconvey the property, all these things must be proved. Then only you can get the judgment on your behalf. Where a person conveys the land, the transferee has a notarial conveyance in his favor. And the question is to be asked is whether transferee has beneficial interest in the property. Are there any rights still outstanding with the transferor? Then the question is very clear. Transferee has the beneficial interest. If the transferee has the beneficial interest, there is no trust at all. But there are some rights outstanding with the transferor. Then there's a trust. Among other factors which may be taken into consideration are whether the consideration paid adequate, sufficient consideration paid. That we must consider. Then the other one we must consider whether the transferor remained in possession and for the purpose of which the property transferred. Then here we must take into consideration that payment of amount, whether the payment of consideration is adequate. And second thing we must consider the possession, whether the transferor is in possession continuously. These two matters very important. Now we will move to other slide here. In some cases where there was held to be no trust, either transferor remained in possession or stated facts provided no indication as to who was in possession. The new approach and agreement to reconvey could be, or agreement to reconvey could also come within the provisions of 96. That we will see what is 96 in the next lectures. Now we will stop with this one. When we start, we will discuss this one slightly and further we will go to the balance part of this PowerPoint presentation. Now what we have studied, simply summarize. Section 83, or when you talk about constructive trust in the sense the trust arising by operation of law or by construction of law, one part. Second thing is the constructive trust arising in certain circumstances given in chapter 9 of the Trust Ordinance, specifically section 83 to section 98. Those are the circumstances under which the trust may arise. Finally, we have seen the issue in 83. We have seen the owner of the property transfers the property to another person. But from the attendant circumstances, we cannot infer that he intended to transfer or dispose the beneficial interest to the transferee. Therefore, property is transferred, not that beneficial interest. Beneficial interest with the transferor. In that case, transferee must hold the property for the benefit of transferor. If the transferor is dead, then transferee must hold the property, legal representative of the transferor. That is the end of lecture. Now we will follow this lecture in the next lecture. Thank you very much.